El uso del derecho de autor en procesos marcarios.
The use of copyright and unfair competition as fact. Brett Heavner, partner of Finnegan, U.S. María de Los Angeles Lombeyda, partner director of the intellectual property area and co-director of competition area and AVL Lawyers, Ecuador. Brian Rupp, Vice President Intellectual Property Counsel in Warner Brothers Discovery, United States. Moderator Lorena Mersan, partner of Mersan Lawyers, Paraguay.
Hola, hola, muy buenos.
Hello, good morning, everybody. Well, we're going to get started with today's workshop. But first of all, thank you to the Executive Committee of ASIPI for allowing me to moderate this workshop. To the panel speakers we have today, thank you, Brad, Andy, and Brian. And of course, all the brave ones who are here with us today after the beautiful party last night. Well, the goal of this workshop is to analyze the basis and arguments that we have available, complementary in industrial property conflicts. On the one hand, we have copyright as a main defense or complementary defense in case of banking processes, and on the other hand, we have the use of unfair competition when industrial property rights are not enough. First, we'll hear from Brian, who will be talking about when they had to resort to copyright in bank processes. Then Brett will talk about cases of unfair competition where you had to use this action when the industrial property rights were not sufficient. And finally, Andy will look at this from the Latin American lens.
For being here, both the three of you.
Gracias, Lorena. First of all, I just want to echo what Lorena said, that it's such a privilege and an honor to be here in this event, and I want to thank Luis and everyone that's worked so hard behind the scenes to make this happen. I think these events are wonderful and really important. So what I'm going to do just quickly today is give you an example of what the Warner Brothers Discovery brands are, so you have an example of what we do at our company, and then talk about some of the brand enforcement issues that we've had and that we have. First of all, so a little bit of, I'm not going to go through and give you a history on the company, but just quickly, Warner Brothers Discovery now consists of what used to be HBO in New York and Discovery in Maryland and TNT, Turner, CNN in Atlanta. On our Max service, we just released a Ted Turner documentary last week, which I encourage you to take a look at. It's really interesting, the history of CNN. I don't know about you, but I remember in 1990 being in Argentina and watching the Gulf War on CNN, and in college running home to watch CNN. And there's a lot of interesting history. And then we also have Warner Brothers, which is in Los Angeles, and then on Max also there's a really interesting documentary on the Warner Brothers. So I'm going to run through our brands so you have an idea of what our company does and what I'm talking about, and then I'll get into some brand enforcement. First of all, we have our motion picture group, which is Warner Brothers Picture, New Line Cinema, and our animation group. These are some of our movies. Barbie, of course, did an amazing amount of money recently. Wonka was really good. These are some of the New Line favorites. I'm sure you're familiar with those. Lord of the Rings. And then animation, We have a lot of animation, and we have a lot more coming out. Then our television group, which when I started at Warner Brothers, I supported the television group. Warner Brothers Television Group, we produce TV, probably one of the biggest TV producers in the world. Everything from Bachelor that we sell to Disney, ABC, Ted Lasso that we sell to Apple. We make a lot of TV shows, and hopefully some of it's good and you like it. More TV shows. And DC Comics, we have a Superman movie coming out in July. Hopefully it's amazing. Hopefully everybody gets a chance to see it. Run through some of our DC characters just so you see what I'm talking about, what we protect. I'm not going to talk about all these, but just to give you a feel, some of our major characters. No CCs if I'm too close to this. DC characters, Warner Brothers games. Our Hogwarts Legacy game that came out recently was amazing, really a big game. More game brands that we have. Midway is one of our brands. Mortal Kombat. So the Cartoon Network, also one of our properties out of Atlanta, out of Turner. Boomerang, one of the cartoon channels. I don't want you to think I'm going too fast. I just want you to give you a feel of what we're dealing with here. Harry Potter, of course, with J.K. Rowling is very important to the company. Wizarding World. And we have more games coming. We also do live experiences in Abu Dhabi and in London. Hanna-Barbera is the favorites from our childhood cartoons. Flintstones, Scooby-Doo, Yogi Bear, and then HBO, of course. Everybody loves HBO and Game of Thrones and Sopranos, Sex and the City. I won't run through the history, but just to know that that's where we start out. So Max is our big streaming service now. We've rolled it out in about half the countries, and we'll be rolling it out worldwide. We used to have HBO Max, HBO Go, HBO Now, but it's Max now. Hopefully everybody's getting a chance to take a look at that. Behind Netflix and Disney Plus, we're really growing and making a lot of progress. We have some originals on Max, more to come. So Wizard of Oz, if you watch this Ted Turner documentary that I was mentioning, it's really interesting that Warner Brothers Discovery owns all the old MGM library because Ted Turner had the foresight to buy it back in the 80s. And so MGM, of course, is spun off in a separate company, but the old MGM library is part of Warner Brothers Discovery. What color were Dorothy's shoes in the original book? Silver. So in the movie, it's red. So if anybody does anything with red shoes, we're coming for you. Okay, we're going to skip some of this trivia. Tom and Jerry, one of our properties. Gone with the Wind. I just made my kids watch this the other day, 4 hours. They thought it was the most painful thing I made them do in their lives, but history has to be reviewed sometime. Casablanca, Looney Tunes, Discovery now is part of the portfolio. We had a lot of Discovery shows. Food Network. Yeah, so on Max let me go back here one. The Olympics, we had all the Olympics in Europe was on Max this last summer, so that was a really awesome opportunity, and more to come on that as well. Magnolia Network, Chip and Joanna Gaines were really big, at least in the United States, with their home business, Magnolia. And then, anyway, this is just an idea of Discovery Plus is still a service that's pretty popular. And we have, of course, the T-Nets. We've had in the news recently a lot about the Inside the NBA, which is a basketball show that we make with Charles Barkley and his fellow hosts, which is really a important show. CNN, I talked about that, launched in 1980, most important news show, 24-hour news show channel when it started, and still very important, and a bright future ahead of it. Some of the CNN shows that we have right here, and some of our sports brands that we have. Okay, now this is what I want to get into in my few minutes that I have. Give you an idea of the brand enforcement issues that we deal with every day. I could literally put thousands and thousands of examples up here to show you every day what our team is dealing with, which is a very small team. So I'm just going to give you some examples. Then I'll let the experts actually talk about the importance of what we deal with this. But every one of these examples that you see right here is an infringement of Superman. So on Superman, the shield that Superman has on his chest, and when he opens his shirt, that's one of the most famous iconic brands that we have. His hair, his glasses, everything that we have with Superman. So in each of these examples, you can see people how they've infringed it. It's crazy what people do. People will start their business with this. They'll file trademark applications for it. They are constantly coming up with creative ways to rip off our brands. And thanks to all of you, we're trying to stop them. Here we have more Superman examples. It never ceases to amaze me how people take our brands, and most of these people, I'll call them and I'll say, you know, what are you doing here? You stole our brand, and they say, well, I had no idea, I just thought it was cool, and a lot of people we can work with. A lot of this is education, getting people to understand the importance of brands, and then of course we also have lawsuits and brand enforcement and collecting damages. So this is another Superman ripoff. When I started the company, Superman was my property, so I have lots of Superman examples because you wouldn't believe this, but I probably sent, for like the 5 years that I handled the Superman portfolio, I probably sent like 2 or 3 demand letters a day just on different Superman infringements. And then I've asked my colleagues to send me some that they deal with. Superman, this is Superman heavy. All Superman ripoffs. Flash, Wonder Woman, Aquaman, everybody takes our property and they want to go and do something cool with it. Batman is probably one of our most famous properties, and they're also always ripping that off too. So it's interesting that my colleague that handles DC Comics, in his office, he has a encyclopedia that's probably 2 inches thick of every DC Comics character from 50, 70 years of history. And so the question is, how do we protect that? Do we protect it through copyright? But can you file trademark applications for every character that has ever been released in a comic book? It would be financially impossible. So what the difficulty with our job is that the movie producers are going through these comic books and they're trying to find a character, and they come to us and they'll be like, hey, we want to make a movie out of this character. And we're like, that comic was released 30 years ago, and now somebody named their company that in country X, and somebody else is using it as their social media handle, and then we have to start from scratch. If we had unlimited budgets, we could protect everything, but that's not the world we live in. It's a very difficult industry, in the entertainment industry. When we started the movie business with Warner Brothers and Disney and Paramount and in the old traditional movie studios, it was competitive then, and now we have Apple and we have Amazon and we have all these other companies that are also in the entertainment space, so it's a difficult space. Here's some other infringements, examples of Scooby and Papaleguas. The Warner Brothers shield right there is iconic, and people always use it. Hogwarts, Willy Wonka. We had people running pizza shops under the Wonka brand, and like, what? Why can't I use this? So thanks to all of you that are helping us stop this. It's amazing that Friends. I spend so much time on Friends. I don't understand it. I mean, I don't know if I can say this publicly, but I watch the show, but I'm not crazy like some people that watch every episode. But I think we go after Central Perk cafes in like so many countries, and Friends is so popular still. And I started watching it recently, and I see why it's so interesting. But it's crazy trying to protect Central Perk, which is a key element out of the Friends TV show. And that's it. So I'll let the real experts take over and tell you how we actually stop this, and then happy to take questions at the end, I think is the plan.
Thank you, Brian. Brett, you gonna go ahead?
Good morning, everybody. Thank you very much for having me here. I will say my visuals are not going to be quite as exciting as Brian's, since I don't have any film. My topic today is talking about how you can use U.S. unfair competition law to handle cases where IP infringement is failing. You're not able to do a kind of traditional trademark infringement or copyright infringement. So that kind of begs the question, why would a typical infringement case fail? Well, in the trademark realm, you might have distinctiveness problems. You might have trouble actually showing that the plaintiff is the owner of the trademark, or it's possible that the defendant may not typically be using the mark in commerce. That's one of the requirements for an infringement case. The defendant actually has to be somehow commercially using the mark. Or you may have likelihood of confusion problems. In the copyright realm, you may have a copyright case fail because there's no way to prove that the defendant had access to the original copyrighted work, or that maybe the original copyrighted work has fallen into the public domain. Or maybe a concern about whether the plaintiff can actually prove that they're the ones that own the copyright. So fortunately, under US law, we have unfair competition. Let's see. This slide doesn't look like it came through. Nope. All right. So there's actually 5 different types of unfair competition that I'm going to be talking about. The first is a false designation of origin claim. This allows you to go after someone that is using some terminology that falsely identifies the origin of a particular product. This is under Section 43A of the Lanham Act. The second one I'm going to be talking about is false advertising, which is also under Section 43A, but a different part of the Lanham Act, where someone makes a particular statement about either their product or someone else's product that is misleading as to the quality or characteristics of that particular product. The third that I'm going to be talking about is a false endorsement, where someone makes a statement that suggests that the plaintiff has somehow endorsed or sponsored or approved of a particular product or service. This is both under the Lanham Act, or it can be under state law, under rights of publicity. Then we get to this slide, which does have the actual test for the last two. The false suggestion of a connection. This is a situation where someone is trying to register a trademark that, although the complaining party doesn't actually have trademark rights, they can say that the proposed application falsely suggests a connection with their identity. And the last that I'm going to talk about, if I have time at the end, is common law misappropriation. And this is a state law claim in which someone has created a property of some sort through their labor, skill, money, etc. And the defendant has made unauthorized or improper use of that property to the detriment of the plaintiff. This typically comes up in kind of hot news type situations where someone has created news or information and someone has stolen that information and used it. So let's look at some cases. Oh, okay, it looks like some of my slides are not coming through. Well, unfortunately, we're going to have to go without some of the visuals. So the Gilliam case, this is kind of the grandfather of all unfair competition cases that were used to fix problems related to trademark or copyright claims. In Gilliam, Terry Gilliam, I don't know if people are really familiar with the Monty Python comedy troupe from BBC, but Terry Gilliam and his partners had this sort of absurdist television show that featured a lot of sexual innuendo, men performing in drag, making fun of the Spanish Inquisition, showing people vomiting on film for kind of the comic effect. The show was popular in Great Britain, and so BBC, which had the contract with the comedy troupe, was permitted under a license from the comedy troupe to sub-license it out worldwide. So they could have the television show rebroadcast in the United States. So BBC exercised that right and had a license with the American Broadcasting Company. So the Monty Python show was being broadcast in the United States. Unfortunately, American Broadcasting thought that some of their humor was a little too risque for the American audience in the 1970s, and that the wholesome American audience would be offended by some of the things that were on the show. So ABC went ahead and just edited the crap out of these shows. So much so that they really weren't funny anymore. And needless to say, Terry Gilliam and the Monty Python troupe were really unhappy about that. They were in a bad spot, however, because what could they do to stop ABC from broadcasting this horrible, truncated, unfunny, boring version of their show? Well, they really couldn't do a copyright claim because BBC had the license to the copyright, and they certainly had a right to allow ABC to rebroadcast it in the United States. So no copyright claim. And U.S. law doesn't recognize moral rights. I know a lot of European countries give artists moral rights kind of as an extension of copyright. That does not exist in the United States. Well, they couldn't really do a trademark claim either. There were some problems with that because under the license, ABC was permitted to use Monty Python. And although the show was edited, it was actually their show, so it wasn't really a counterfeit. So what were Gilliam and Monty Python going to do? Well, they went with the false designation of origin claim. Their argument was there was no way for the American audience to know that this show had been horribly mutilated by the editors at ABC. And the argument was the continued use of the Monty Python trademark on the show was a false designation of origin, because that show in no way reflected their original artistic creation, and it damaged their reputation. And they were successful in doing this. What was interesting, even though they were successful in the first instance, the district court only granted a very limited injunction, basically saying all ABC had to do was put a disclaimer at the front of the show and say, oh, well, this is not really what they wanted. Terry Gilliam and the other Monty Python actors were unhappy about this, and they appealed. And on appeal, they were successful in getting the Second Circuit to say, no, there should be a complete injunction, and that ABC should not be permitted to rebroadcast the edited show at all. So I think this is a great example of how you can use unfair competition to accomplish your goals and protect your brand, as it were, when traditional trademark and copyright is not really available. A more recent case that I want to talk about is Chanel versus Real Real. In this case, Real Real was a online consignment shop that basically sold gently used designer goods, by Chanel, Hermes, Rolex, etc. And Real Real made a big deal in their advertising that all of their products were 100% real, that they had this great authentication process. They had expert authenticators that would be able to look at what's being sold and make certain that they were not counterfeit. They suggested they worked closely with the designers, but Chanel was very suspicious about this, and so they did some test purchases, and they discovered at least 7 bags that were labeled with Chanel that were total counterfeit, that were not real at all. Although they did have to admit that the vast majority of the Chanel merchandise being sold on Real Real was actual, authentic Chanel goods. So Chanel, of course, brings a standard kind of counterfeit claim. And they are successful because it's clear that the 7 bags are counterfeit goods. But Chanel's not happy with that. They think they want more in the way of relief. They really would like to get rid of the Chanel mark and logo on the Real Real website altogether. Unfortunately, they were unsuccessful in doing this because the court said, well, they really are selling actual Chanel goods, and the site clearly says that it's a consignment retailer, that it's not like official, and so there's probably some nominative fair use here. Well, what's Chanel going to do? Because they're still extremely uncomfortable with what's going on the Real website. And so what they did was they pursued a false advertising claim, and focusing on the fact that the statement 100% real is literally false, because they've shown that at least 7 of the products were not real, that they were total counterfeits. They went further and also said that a lot of the description of the authentication process was maybe technically not false, but was misleading to consumers, because it suggested that somehow they had worked with Chanel, and that and the consumers may not understand that the authentication process was merely kind of an examination and not a guarantee that the goods were genuine. So as a result, Chanel actually accomplished a lot of its goals by going after these sorts of statements that they were uncomfortable with. So even though they couldn't prevail on every trademark theory that they really wanted to get the Chanel mark off the website, they did accomplish a lot of their goals using unfair competition. Now, the next case that I want to talk about is the Beastie Boys versus Monster Energy Company. Beastie Boys, as you all know, is probably a extremely popular but now kind of dated musical group that had kind of cutting-edge music, and they made a big deal that they were not commercial. They were not going to allow their music or their names to somehow be used to endorse anybody's product. Monster Energy, the beverage company, they sponsored every year a sort of a snowboarding competition, and at the end of the snowboarding competition, they would create this recap video. And the videos became very popular on YouTube and other online sources. And they would have music in the background on the video. And in this case, they used music by the Beastie Boys. In fact, they used about 5 different songs, and they also included the Beastie Boys' names in the video recapping this snowboarding competition. And, of course, given the Beastie Boys' preference for not endorsing anybody's product, Monster Energy did not have any permission to use either the music or the Beastie Boys' names. Well, Beastie Boys were obviously upset about this, but they had some problems with their infringement claims. They didn't pursue a trademark infringement claim because it was probably nominative fair use. That really was their song. And they had some issues also with the copyright claim. Although Monster Energy kind of conceded that they had infringed the copyright, they did not want to admit that it was a willful infringement. And under U.S. law, willfulness is really critical in order to establish significant damages. In the U.S., it's very difficult to prove actual monetary loss of the copyright owner. So we have statutory damages, kind of this scale of amounts of money that can be awarded at the discretion of the judge based on how bad the infringement was. And of course, if it's willful infringement, knowing infringement, you get a much, much higher amount of statutory damages than otherwise. So one of the concerns for the Beastie Boys is, would they be able to establish significant actual damages? Probably not. And so in the absence of willfulness, they might be stuck with a pretty minimal statutory damage award. So what do they do with that situation? Because they're not happy about it. Well, they instead went for a false endorsement claim under the Lanham Act. Basically, they said, look, this looks like we are somehow official sponsors of this Monster Energy drink or what have you. And they succeeded in doing that because the court said, look, this is not the same as a copyright infringement claim. It really addresses other types of damages that the Beastie Boys experienced by making it look like they're, selling out to the commercial temptation to sell their name for endorsement purposes. And It's clearly an intentional false endorsement because they used not just one song as background, but 5 songs, and they included the Beastie Boys' name. So the Beastie Boys prevailed under this, so they were not stuck with a relatively modest copyright claim, but instead had a much greater damages award under this unfair competition theory. So the next case I want to talk about focuses on the way you can get around trademark problems in the US Patent and Trademark Office. In this case, there was a fashion model, Twiggy, who was very famous in the 60s for being slender and fashionable and mod and hip. And although Twiggy was not her actual name, that's what she went by. And after her career kind of ended, she continued to stay in the spotlight. She was kind of a host on different media television shows. I think America's Next Top Model had her on there. So she was, continued to be known by Twiggy and was famous up until recently. Another company called TJX applied to register the mark Twiggy for a high fashion line of children's clothing. And although they didn't specifically use her image, it was clear that they thought Twiggy was for kind of slender children and they were kind of hip and mod. Well, Twiggy did not like that. The model did not want them to register the Twiggy mark, but she didn't have a trademark registration for Twiggy. And she probably didn't really have any common law rights because although she did have a line of clothing that at one point in time she produced, it was not sold in the United States. It was only sold in the UK and Japan. So her trademark rights were pretty weak. And there was no evidence of any US sales, even though this line of clothing did exist. So what was she going to do? Well, she went with unfair competition again. Under Section 2A of the Lanham Act, you're not allowed to register a mark that uniquely points to someone else and falsely suggests a connection. And she was able to show that her name Twiggy was still in the public spotlight. People knew her from her presence. And in the fashion industry, Twiggy unmistakably points to her. So consumers would presume that this Twiggy line of high fashion children clothing was somehow related to her. So this is a good example of how even if your trademark rights are not really available, you can, if you can prove these sorts of fact scenarios, stop someone from registering a trademark that points to you or your institution or your company. And the last case I want to talk about is the kind of the hot news or misappropriation type scenario. In this case, Barclays Capital puts out a much sought-after report on a daily basis that has stock recommendations, has predicted value, and these stock information or financial information really is only valuable for a few hours early in the morning before the stock market opens, and it is their most important asset. Flyonthewall.com operated its own kind of subscription stock news service, and it managed to somehow surreptitiously get early information about what Barclays was going to say in their news report, and then repeated it in their own verbatim news report. So they basically stole all of that information that Barclays put together for their subscribers. They did have some summarized information as well, so Barclays, sued for a copyright. But there are some problems with their copyright claim. One, outside of the verbatim copies, one of the things that the Fly on the Wall argued was, well, we can still use the facts that we found. Facts and statistics are not protected by copyright. Copyright only protects the expression of certain ideas and information, and so we ought to be able to just go ahead and repeat the facts as long as we're not quoting Barclays. So what was Barclays going to do? They're not going to be happy with them taking the facts and the statistics that they worked so hard to develop. So they filed under a New York state law a misappropriation claim. And they were successful in using this hot news kind of misappropriation because they could show that they had generated the information at a significant cost, that it was time sensitive, and that the fly on the wall had taken it without their permission. The case ended up going up on appeal, and it was overturned on the idea that it was really preempted by copyright law, that it was really a copyright claim. And I think that the thing that actually kind of sank Barclays on this was they really couldn't point to evidence of statistics or data being used that wasn't an exact quote of their service. So they needed to have more information on that. And that basically ends my presentation. The takeaways are, think about, don't necessarily give up on taking action against someone that is infringing because you think your trademark claim has flaws in it or your copyright claim has flaws in it. U.S. unfair competition law is a very, very useful tool, and can respond to a lot of problems that you want to have resolved when you can't do it with a traditional trademark or copyright claim. Thank you very much.
Thank you, Brett. Angie?
Buenos días. Buenos días.
Good morning, everybody. I would like to thank the Executive Committee for the invitation. Thank you, Brian. Thank you.
Say something. Friends is the best TV show ever. Gracias a todos.
Thank you, everybody, for being here, because we know you're coming from the studio party and you have to be brave to be here at 9:30 a.m. to listen to us, so thank you very much. Let's get started, and we'll take a tour through Latin America. I would have loved it to be lengthier, but we had to pick the most significant cases to analyze them here with you. Let's start this tour. We will analyze, first of all, what are the factors that we'll take into account, what definitions that we consider more relevant to analyze these topics. In first place, we'll have unfair competition. Second, copyright. Third, I would like to introduce in the room the principle of relative complementarity. And third, the challenge for lawyers is the evidentiary difficulty. Let's start unfair competition, and you'll ask, well, if we're going around Latin America, why do we start with Spain? And I have my master's teacher, Mr. De Santis, and you'll see why. In the case of the Andean community that I belong to, because I'm from Ecuador, we've taken as a point of reference the unfair competition law from Spain to draft the different legislations in terms of unfair competition in the countries of the Andean community, especially Colombia, Peru, and Ecuador. That's why it's so important. We will not analyze, if you give me a second here, because I got ahead of myself here. Yeah, there we go. Here we go. We will analyze the complementarity principle, which is legal criteria. This allows us to enrich the discussion. The principle of relative complementarity starts from a fact that is almost evident, and that is that intellectual property and unfair competition are two worlds that are related but are different. They have a different protection object. We'll see, first of all, that intellectual property, specifically industrial property, is a subjective right. It's a non-material asset, it's a real special right, therefore is erga omnes, and requires a registry for its protection. At least in the continental law countries, it requires a registry for its protection. Unfair competition, on the other hand, what does it pretend? It seeks the correct operation of the market. Those covered by unfair competition is not necessarily the owner of the brand. Why? Because unfair competition has a threefold protection. What does this mean? It means that it has 3 points of protection. First, you have the market. Secondly, you have the consumers. And lastly, you have the economic operators. Therefore, there is an interaction between these two worlds, but these are two different worlds. Here we go. How do you apply the principle of complementarity? When does it apply to unfair competition? When does unfair competition start to govern in industrial property topics? And case law in Spain has a lot of analysis, abundant analysis. You don't resort to unfair competition standards when behaviors are fully included in the IP laws. If IP laws already encompass this, you don't have to resort to unfair competition. However, you go to unfair competition if the behaviors with exploitation of a distinctive sign presents an anti-concurrent dimension, is when it distorts the market and affects the market. That's when unfair competition kicks into action. The undue use of a brand as such, and this is, we like to use as lawyers unfair competition, but the undue use of a brand is not always unfair competition, and we have to analyze this with caution. And here have the consequence of the foregoing. The judge will determine whether it's convenient or if you have to apply or not unfair competition according to the arguments that we present in our claims and according to the evidence. And you'll agree with me that the most difficult thing to prove is bad faith, and that's relevant because of what we'll see shortly. Because precisely what establishes that there's unfair competition, you have to show that there's good faith in the market to have an unfair competition. We have to prove that the contrary exists. As I said before, it's very complicated, but we will see this throughout the presentation. What are the conclusions that case law in Spain allows us to see, and that you'll see not only in the Andean community but also in different countries? That by virtue of the principle of relative complementarity, IP and unfair competition standards apply. Not always, and we have to be cautious to determine when to do so. Therefore, there are actions that are not exclusively based in intellectual property rights when when the consumer or the market are being affected. Okay, now let's go through Latin America. And I have to start, and I apologize, I have to start with what I know best, which is the Andean community. As I said before, the Andean community, for those of you who don't know about it, is made up by Colombia, Peru, Bolivia, and Ecuador. We have a series of standards, but in this case I will focus on Decision 486, which is the common standard for industrial property matters. In Decision 486, there's a series of articles dealing with unfair competition. How do you define unfair competition? In this case, let's bear in mind that this is a standard that dates back to 2000. You use it as an undefined concept to establish what is unfair competition, the honest uses and practices. We've already evolved to a concept of concurrent good faith, and we'll see how the justice courts of the Indian community have contributed to this. What does Article 258 state? That you will consider unfair every act linked to industrial property with which you limit the application of this article in the business environment that is contrary to the honest uses and practices. Bear in mind this concept because we'll analyze it in depth shortly. And we have Article 137 that states that it's possible to file opposition as long as there's reasonable indication that you want to commit an unfair competition act. The Andean Community Court of Justice establishes in several sentences, it defines a series of parameters that allow us to modernize this concept that I was talking about before, that it makes me itch when we talk about use and honest actions. And it says unfair competition are all acts contrary to the concurrential good faith. It modernizes this concept to the new trends, especially the European ones, and it says that there has to be concurrent good faith with intent of causing damage or take advantage of situations that may be detrimental to the competitor. What does an Unfair Competition Act constitute? Is every act that does not have concurrent good faith, and you're going to get bored, but at least you'll remember concurrent good faith, where we attempt to misguide clients or attack the competition through illegal acts. That's simply what unfair competition is. What is the environmental protection? It's a three-party protection that I talked about: market, consumers, and economic operators. What does the Andean Community Court of Justice also say? That for there be an unfair competition act, that has to be an effective competition act. There has to be an act between two competitors in the market. There must be an undue act, and it must be prone to causing damage. It doesn't necessarily have to cause a damage, but it has to have the capacity of causing damage. Now we'll bring down to earth all these concepts in an opposition as a residual basis. First of all, what do we have to do? In a position or infraction, you have to identify what is the infraction sign. In the case of an infraction evidently in the market, in the case of being in opposition, it would have to be that request with which you want to perpetrate an unfair competition act. We must compare the signs in conflict, but we must not carry out analysis of confusion, because confusion in unfair competition is broader, as we already heard from the co-panel speakers before me. Additionally, you must concur in the same market, and in competition we talk about the relevant market, so it must be in the same market. And it also makes sense due to the fact that we have to see and analyze the competitive connection that we always talk about in the oppositions. And there must be advantage. What I mean by advantage is a rupture of the market transparency. There has to be an error in the consumer where we see a coincidence with what happens in the U.S., and it could take place in countless ways, like it had also been analyzed previously, with which we see that there's a connecting thread in terms of unfair competition. Let's now analyze the case of Colombia, and what does the Superintendence of Industry and Commerce say about it? It says that unfair competition, and here we apply somehow the principle of relative complementarity, is the cause of preventive non-registrability. It additionally says that it applies when there's reasonable indications that the request could be used to carry out an act of unfair competition. There must be a causal relationship. This might sound obvious, but in the specific case it's not so obvious. There must be a cause relation between the application for registration and the act of unfair competition, and it operates when there is no other registrationability cause. You cannot have other causes in the ending. It only operates when there's no other cause, and this is also a principle. It's an application of the complementarity principle. Now let's see what Peru says in the copy. It also talks about good faith. In other words, it forgets the concept of use of honest uses, and then you have the concurrential good faith. It says that you presume good faith. It's not sufficient with a request to be considered as an act of unfair competition. There must be the request for registration, another adjacent act to understand that there is an act of unfair competition. There must be a transgression to the competition duties, this good faith that we must all have in the market. An intention to mislead the competitor, and through illegal means. Everybody wants to do it, but how do we do it? That's the thing, and that's where unfair competition starts to act. In the case of bad faith, and the copy says that there has to be a previous acknowledgement of the registered sign, and bad faith must be accredited before the date that the registration is presented. So if you present the registration request for registration December 3, 2024, the Unfair Competition Act has to be prior to that date. Now let's see Argentina. In Argentina, I want to share a case that I thought was very interesting and that it will sound familiar to a lot of you. In the World Cup, and I see a lot of Argentinians looking at me with a question mark in their faces. In the World Cup, Lionel Messi, in an interview, lost his temper and he called the third person. He said, "What are you looking? Just get out of here." The following week, there was a series of requests for registration saying "anda pa allá" or "get out of here," basically. "Anda pa allá." Those in my Ecuadorian colleagues said it better than me. Okay, thank you. "Anda pa allá," or get out of here. And what happened that the patent office in Argentina rejected the registration of the brand, and it rejected it because it considered that it goes against the commercial good faith and mercantile best practices. And I'll read the basis that contains the resolution. And look, it's a resolution that denied the registration, but there's a general resolution that establishes this, and it says, with respect to the pretension to register the brand of signs that reproduce totally or partially words or phrases that have evidently become general use and is associated to certain personalities. It also against commercial good faith and healthy mercantile practices, and it may result in an eventually undue exploitation of his prestige, image, or reputation. This outburst of a very well-known soccer player that when he lost his temper, he said a phrase, and this triggered a number of requests, and it leads to that they're rejecting the brand because they believe that is unduly taken advantage and unfair competition. Let's go to Chile to another case that may sound familiar. Nut milk case. Nut milk brand is requested, and an association of livestock breeders decides to oppose it. The patent office in Chile carries out a very thorough analysis of the case and establishes first of all, and says unfair competition is any behavior that through illegal means seeks to detour the clients. He agrees with all the definitions we saw before. And why does it say that there's undue use in this case? Well, first of all, because in the packaging of the product, there are certain elements that could lead the consumer to confusion. For example, the drawing of a cow that could show the user that they are consuming milk, and it's not, because the brand says not milk. And also that through this request for registration, they try to take undue advantage of a product such as milk. It says that there is an explicit comparison on extremes that are not verifiable, and I think it's also very interesting, and also talks about good faith. And once again, what we're saying is one of the elements, or rather bad faith, is one of the elements that is most difficult to prove. The judge then concludes that there are unfair competition acts that generate a significant detriment for milk producers. Therefore, they reject the registration of the Not Milk brand. Now let's analyze copyright. And I won't go to Spain, I'll go directly to the Andean community here. We have to start from the presumption that there must be work and an owner, and has to meet the requirement of originality That is part of the standards of copyright that generally most legislations of our countries agree on this. You establish the independence of the copyright and industrial property. Although we say that these are independent but compatible rights. And I'm running out of time, and I will only be able to cover the ending community. And it says that in order to determine if there is an impediment for registration, there must be a risk of confusion, as you do in any opposition proceeding. Likewise, another one of the elements that calls our attention in what is mentioned in our legislation, and specifically in the Court of Justice of the ending community, is that you could have the title of works that are well known, in which case, analyzing case by case, it could, or you could apply standards in case of a variety of brands. I'll go to Colombia and I'll finish this because of time. When you have a case filed in copyright and opposition supported on copyright, the Superintendence of Industry and Commerce says that the first thing is you have to prove the existence of the work. Second, that you have to prove the entitlement you have over the work. Additionally, what is requested must be a total or partial reproduction of the existing work, and protection protects the works as an expression of the personality of the author. And ideas circulate freely because we cannot oppose because the ideas agree, but how the ideas have been reflected in works. They're giving me 5 more minutes, so perhaps I can even cover Ecuador. It's an opposition where this is the existing copyright, and this is the sign that's requested. The SENADI, which is the competent office in Ecuador, says that they acknowledge the existence of a copyright. They arrive at the conclusion that both characters that are represented here each one of them have a copyright. That there are some elements that coincide, yes. However, these elements cannot be seized by either one of them, so they grant the registration of the requested sign. In the case of Peru, you'll see that there are certain similarities with the Ecuadorian case. You see to the right the design of a packaging. You see the design of a packaging where in the center you see the humanized design of a duck. In this case, in the copy rejected the request for registration because they thought that they were damaging to Disney's Donald Duck. And it says likewise that there must be originality. That is, you can use ideas because ideas are free. There's no protection on ideas, but it is also illegal to obtain the elements of protected works to transfer these to the request for registry. That's why they reject this registry. In the case of Chile, there's countless cases where it is established, and here it really called my attention one of the analysis carried out by the Chilean brand office. It says that the standards of the Berne Convention are not applicable in industrial property matters to present an opposition. That I believe it's obvious, but apparently some people don't. So I share this with you. The Berne Agreement is not applicable, or is not a cause for non-registration in opposition case. That's why you have industrial property standards that clearly establish what are the basis for non-registration of a brand. It talks about authorship, and there's a connecting thread that it says that it must be a protected work, and to be protected it must be original, and you have to prove the authorship of the work. And also states that the work, and it's something that we all know, works have a time for protection. That time protection time has expired. In the case of Ecuador, for example, is 70 years after the death of the author of the works. After those 70 years, it's public domain. In other words, it's part of the culture of each country. However, you respect the paternity and integrity rights. It talks about the risk of confusion that you must compare to see if there's a risk of confusion of the pre-existing works and the request for registration, and also a competitive connection analysis, which I believe is one of the greatest contributions in this matter from what we've been able to see. And finally, Mexico, and I'll finish here, that establishes that there are points of contact between the copyrights and industrial property. And there's works that, due to their expression, derive in in trademarks, and there's a prohibition of brands of works protected by copyright, and there are standards in the copyright law and brand law that are related and seek to avoid the request of registries that vulnerate copyrights. And I'll end here, and thank you for your time and patience.
Muchas gracias, Andy.
Thank you, Andy. Now we'll go to Q's and A's if there's any questions. Over there. Hello, good day. Well, this topic has been very interesting for me. I belong to the competition of ASIPI. That's one of the topics to review in here. So I have several questions. I don't know if I can ask all of them. First of all, for Warner Brothers, I would like to know, having such a broad portfolio of intellectual property, brands, copyright, characters, I don't know, should I ask in English or in Spanish? Well, if you can do it in English, better.
I can translate.
You have like a big portfolio of trademarks and copyright matters and that stuff. I would like to know, how do you determine which one do you prefer to go to? I mean, to, how can I say, to pursue, to enforce, and which one not? I mean, which will be the key points that you will take into account to take the decision?
That's a great question. Thank you very much for that question. It is a constant battle of trying to look at risk analysis every day with limited budget and limited information, and trying to decide, what are we going to do here? And so there are a number of ways that we decide what we're going to enforce. First of all, we have a massive merchandising element in the company, and we license our brands all around the world. So probably one of the number one reasons that we enforce is, if you're a licensee and you're paying money to use our brand, and there's an infringer that is not paying money, you're going to complain. And when we hear that, we're going to take action. So that's one reason. Another reason is whatever is important to the executives. You know, like I mentioned before, our DC Comics business is trying to reboot. We have a Superman movie coming out in the summer that hopefully will save the world and be amazing. But you just don't know. It could be a Barbie, it could be some other unnamed movie that we all forgot after the week after it came out. So whatever the executives, what's important to them, that's what's important to us, and that's what we try to take action on. But we have, for example, DC Comics, these executives are going through these comic books, and they want to make a movie out of some character that I've never heard of, because I should know more of these properties, but you know, Friends is amazing. So that's one way that we do it. But to be honest, it's so difficult, because there's this vast amount of properties and limited resources. And it's not easy. It's a constant battle every day, trying to figure out what we're going to go after. And we're always getting second guessed in the IP department. That's not to complain, that's just human nature. An executive wants to make a movie from something that was popular 20 years ago, and they come to us and they'll be like, why are there no trademark registrations for this? And you say, well, first of all, I wasn't here 20 years ago. And second of all, they told me to abandon this. They didn't want to pay the renewal fees 15 years ago, and it's a constant battle. It's super difficult. I mean, that is constantly what we battle with every day: risk analysis with limited resources, limited time, limited information. So, yeah, I don't know if that helps, but if you have any ideas, I would love to hear them.
¿Tenés otra pregunta?
You have another question, right?
Lombeyda.
The party really hit us hard. Okay. María de Los Ángeles, I'm sorry. Okay, let me see. I'm intrigued because in Dominican Republic we're making decisions. Our authority related to competition, which is pro-competition, which is not the same as industrial property, which is an IP. They've issued decisions saying that unfair competition cannot. No. Well, I will not use the exact terms, but they cannot move ahead because it has no market interest. There are conflicts between private citizens. You mentioned in your presentation that is a key element to be taken into account because not all trademark infringement would be an unfair competition act. What would be the criteria that you have seen in your research, in your knowledge of the topic, that has allowed or has caused that your competition authority to proceed as unfair competition beyond the conflicts among private citizens? Hello? Yes, there I am. Thank you. Thank you, Magda, for your question. Well, let's see. The competition authority should be competent when the Unfair Competition Act may cause detriment in the market, when it's so large and so broad, when it exceeds that relationship between two competitors and affects the market. To that end, it's important to analyze topics such as market share. For example, what's the impact on the market if there's distortion or falsehood, or what is the position in which the consumers end up in. In Ecuador, we have a standard that, although it's true, is inspired in Spanish legislation, it's also inspired in Chilean legislation, and we have a Frankenstein from both, and establishes that unfair competition acts with that involve industrial property. In our case, it would be SENADI, the competent authority. In the case where there's an impact on the market, the competent authority will the competition authority, which is the superintendence of economic competition. And in those cases where there is no industrial property right, or there's no impact on the market, that is a topic that's only among competitors, there's a legal gap. It was not even discussed. So we understand, and here we have to apply our civil code, our general process code, we would have to apply a civil case. So I'll share with you the solution that I don't think is the best, or at least has not been drafted the best way, but what is a solution? That's a solution that we've had in Ecuador. But I agree that the competition authority does not have to go into industrial property topics, because we'll go back to the residual actions of industrial property. Thank you. Another question? Okay. Thank you for the presentation to all of you.
Very enlightening. Tengo una pregunta para María de Los Ángeles.
I have a question for María de Los Ángeles, and it's on copyright as well. Because, for example, now in this world where everything is social networks, where everything is digital agencies, you have the creation of logos, and companies do the filing for the registration of logos, but the designer behind that, the creator of the logo, has a copyright. In most countries in the Latin community, I am from Peru, I'm part of that. Copyright is not a constitutional but a declaratory right versus the banking right, which is constitutional. So the company that does the filing obtains the registration, but the author of the brand, what is his or her right? He just seeded it, or should you generate contracts between the designers? What should prevail in the case of conflicts? Thank you. That's a PhD thesis question. In any event, I would like to just give you my opinion. I don't believe that there could be a tacit assignment. It has to be an express assignment. We know that this does not take place in practice, but there should at least be an assignment contract. Often designers belong to agencies, and these agencies have work contracts, and here we do have a variation in terms of copyright. There is a variation in the standards in all four countries because the decision 351 is quite vague when talking about these topics. In any event, to close, I would say that there has to be a contract in place, that we have to take into account, in addition, what is the relationship between the designer and the agency with the advertiser or whoever ordered their work, and we have to analyze. And here's the most complicated thing: it's the moral rights. How do we enforce the moral right of integrity or paternity in the case of a slogan that could change or could morph, or how to respect the paternity right and make evident the name of the author in advertising, where generally in practice that is very complicated. So I am aware that I did not answer your question. I tried to outline it somehow, but it's very difficult. And the suggestion that I always give my clients is you have to have a contract in place. In terms of copyright, there's no presumption of assignment. Thank you for your question. Matias. Hello. Thank you, Lorena.
For Brian, how do you watch like the characters, the properties? I mean, you showed a lot of infringement cases for Superman, but many of those were like difficult to detect. It may be in both, I mean, trademark applications and maybe uses of or wrongful uses. So how do you watch that? And if you currently have any AI, platform or service, I mean, to do that type of watching?
Hola, Matias, gracias. Yeah, so we have watch services around the world for trademarks, of course. We have the licensees that report things to us. Local council constantly sends stuff to us, and we appreciate anything like that. I know the big complaint is that council sends us something and we don't act on it. A lot of times it's out of our hands. It depends on budgets and resources and what the executives have us do. But yeah, we're constantly, any way that we find out about anything, we're grateful for that. So that's the first part of your question. On AI, now you're wondering about AI as far as watching or AI in production? Can you tell me this? Yeah, we're looking into that because we have some of these watch services that our paralegals get. I can't remember the exact number, but it's like 1,000 watch notices a week, and they're trying to weed through this, and 90% of the hits are just not relevant. So we're looking at ways to get better results from our watch services. Because you take some character name that's, I can't think of it off the top of my head, but some random common name, and you get 1,000 hits a week. I mean, how can you possibly use that? That's not efficient use of time. So we're looking into that, but we don't have a good answer, I don't think, yet to watch with AI.
Okay, thank you. Bueno, vamos a ver por... Martín, una última pregunta y después cerramos.
Okay, this will be the last question, and then we'll close it here.
And educated presentations. I have a question for Brett regarding the Barclays case. If I correctly understand, it seems to be that the defendant surreptitiously obtained Barclays capital records. Did you consider initiate against them some trade secret actions?
Okay. Yeah. So I think the problem with the trade secret was that the information that was being circulated was not going to be secret. The point was, I suppose you could say in some respects it was secret before it was published, but I think what they got was they maybe had a contact that was an official subscriber to the Barclays service, who then instantly transferred that information to flyonthewall.com. So a trade secret thing was not going to work because the information that they were circulating was no longer secret. The problem is that they somehow, got it from someone who was essentially, I think, breaching the subscription license. The idea, when you subscribe to these services is, you're not supposed to share it with anybody else. And they managed to find someone who was willing to do that. And so as a result, they were able to incorporate that subscription into their own subscription and pass along Barclays, hard-earned and hard-researched advice for their subscribers. So that's why they kind of had to go with the hot news misappropriation type of claim, because it was no longer secret.
Okay, thank you. Bueno, vamos a dar por finalizado el panel. Thank you,
Okay, this closes the panel.
Angie and Brian, for sharing your experiences and time with us. Bueno, muchas gracias a todos por su...
I would like to thank everybody for your participation. Thank you.